Engagement or betrothal is not exchange of consent. Canon 1062, paragraph 1 of the Latin Code says that a promise of marriage, whether unilateral or bilateral, called an engagement, is governed by the particular law which the Episcopal Conference has enacted, after consideration of such customs and civil laws as may exist. The paragraph 2 of the same canon says that no right of action to request the celebration of marriage arises from a promise of marriage, but there does arise an action for such reparation of damages as may be due. Engagement is a formal promise of marriage by the partners. It is a bilateral promise between a man and a woman to enter a sacramental marriage, within the time specified by the same parties. It is governed by the particular law of the churches. In India, for the Latin Catholics, it is governed by the decree given by CCBI and by the custom and tradition of each diocese. For the Orientals it is regulated by their own particular law. Normally the engagement ceremony is done after the prenuptial inquiry. The banns follow the engagement. Engagement does not create legal obligations to have the celebration of marriage. The formal promise given in engagement and the matrimonial consent are juridically different. It is true that the promise includes some moral force. But it does not legally bind one to marry against his or her will. No one, therefore, can file a case against the break of the promise given in the engagement. However, if the engagement is disowned, the money matters, financial transactions or gifts done in view of the proposed marriage are to be settled. If not, just compensation can be obtained through civil case. Thanks for watching. For more videos on the understanding of the Christian marriage, kindly subscribe to my YouTube channel, Canon Law Explained.